I'd say confidently that the Attorney General's office has competent attorneys to review these documents before they are signed. As the principal legal advisor to the government, the office advises the government through its departments and agencies on these agreements. It is quite often the case, and sadly so, that the AG's office is sometimes not involved in the negotiations and discussions leading up to the execution of these poor agreements. In quite some instances, I'm afraid to say that the opinion of the office is not sought prior to execution, or the agreements are executed irrespective of the reservations raised by the office. Ladies and gentlemen, more often than not, and this is evidence of how things have played out, the issues that take us to the courtroom or before a arbitral tribunal has to do with the abrupt abrogation of these agreements or the contractual breaches. Defending the public purse in a situation where there is little to no information or support coming from the institution or ministry involved also poses a great challenge to us. We at the Office of the Attorney General do not exist as a state machinery with a magical wand to wipe away contractual breaches or the judgment debts after they have occurred. We may have our very rare shortcomings indeed, meeting some procedural obligations in international arbitration proceedings. However, it is most often than not that it boils down to our office being handicapped because the institutions involved are not forthcoming with the information required to defend the state. I must say that in these situations, not even the highest fidelity and procedural compliance can absolve us from the realities of a bad case as the merit of the case is determined. The execution of poor international agreements, the payment of huge judgment debts, and the recurrence of these phenomena by governments is no doubt a major threat to our national development. A holistic look at sustainable ways of dealing with judgment debts devoid of political games is needed. Some people have advocated for legislation to limit the amount in damages contractors and governments can claim in the event of default or breach of a public sector contract. That government contracts should have clauses that limit damages in case of default, breach of contract, or litigation. Some also clamor for the formulation of a judgment debt management policy and a register of all government contracts to be reviewed before they are executed. I am very confident that the outcome of our deliberations here, steered by the rich panelists who have a wealth of experience here today, will have far-reaching impact on our disposition as a democratic state. And so finally, I urge all of us to be blunt with ourselves and interrogate thoroughly the causes of these poor international agreements and judgment debts.